So for the next speakers of the day, we have Mr. Jake Lowther and Raoul from SEC Arbitration Institute. We're pleased to welcome Mr. Jake Lowther, representing the SEC Arbitration Institute, one of the world's most respected forum for international dispute resolution since 1917. Mr. Lowther, a specialist counsel at the SEC, brings a wealth of experience from his legal practice across Australia, Korea, Germany, and Sweden, with a strong background in dispute resolution. His expertise reflects the SEC's commitment to neutrality, innovation, and global engagement in arbitration. We cordially invite Ms. Jake Lowther to share the insights on the realm of ADR in Sweden and contribute to today's dialogue. Raoul Sievers is a PhD candidate specializing in international arbitration at Humboldt University in Berlin. He is enrolled in the LLM program in International Commercial Arbitration Law at Stockholm University and serves as a visiting professional at the SEC. His academic work focuses on collective arbitration as well as on issues of arbitrability and public policy in arbitration proceedings. Prior to joining the SEC, Raoul worked with the international arbitration team at Fresh Fields in Berlin and Frankfurt. Raoul began his legal career at Brian Cave Lighton Pesner, where he worked as in the M&A restructuring team. Over to you, gentlemen.
Thank you very much for those kind introductions, and also to the organizers for this excellent event. We're very, very thrilled to be here. So good morning from Stockholm, and good afternoon, good evening, wherever you might be in your time zones. This is very exciting to be part of such a global event. If we go to the next slide, please, we can probably skip to slide 3, actually. I'm here and delighted to be able to talk about one of our favorite topics, which is the SEC Arbitration Institute. Exactly. So here we are in Stockholm. We are an independent part of the Stockholm Chamber of Commerce, which is a members-based organization, independent of the government, and there to act in the interests of its members. And we have, since 1917, provided a neutral platform and an impartial process for the resolution of disputes around the world. Now, the next point I have on my slide is in inverted commas, the world's most modern arbitration institute. We in Sweden try and be quite humble about this, and so we therefore put this in quotes rather than just saying it directly. But I dare to say that this is true, and we will talk a little bit about why in a second. Next slide, please. Yeah, so as an organization, you can see that for us, from up in the top of the map there in Sweden, we have an extraordinary global reach. And last year, we had parties hailing from all of the inhabited continents of the world coming to the SEC for dispute resolution services. So it's truly an impressive reach. We also had over 200 cases last year, and we are on track to have a similarly good year this year. We are very proud of the fact that it is a very international organization and an international caseload. And we are very pleased that parties from all around the world have entrusted us to administer their disputes, which is, of course, one of probably the worst times for a business to have to be engaged in. Next slide, please. So as I mentioned, the SEC was established in 1917. This was essentially based on the needs of the members of the time who needed a neutral forum outside of the courts for the resolution of their disputes. As you can imagine, in 1917, the disputes looked a little bit different to how they look today. And we have seen from that history disputes in relation to agricultural goods and commodities, and then moving up to from horses to cars to green technology today. But what really made us so international, you might wonder? Well, during the Cold War, Stockholm was a bit of an outlier in a way. We were not entirely in the Western sphere. The Swedish position on the Vietnam War meant that there was no US ambassador to Sweden for some years in the 1970s. But Sweden was not behind the Iron Curtain either. So we were not in the Soviet sphere of influence in that respect either. So the two sides, when confronted with difficulties, were able to choose and decided to choose Stockholm as a neutral place for their dispute resolution. And in 1977, this was actually agreed, put into writing between the two sides in what is known as the optional clause agreement. This was then followed in China when the cooperation agreement with the China Council for Promotion of International Trade specifically referred to the SCC and Stockholm. And this position, in fact, led to what we will also talk about today, and that is Stockholm and the SCC's role in the arbitration and in the administration of investment disputes. So in a number of bilateral and multilateral investment agreements, they refer, in fact, in some way or form to Stockholm and the SCC. And since the early 1990s, the SCC has administered these disputes between investors and states. Next slide, please. Thank you. Yes. So as you can see, our modernness, if you will, it's really, I think you could go back to the mid-90s, staying in the 90s, when the SCC was among the first institutions to introduce an expedited procedure. One of the criticisms that isn't, in fact, terribly recent about arbitration is that at times it's not sufficiently efficient in terms of time or cost. And in response to these criticisms, even in the 90s, for those disputes that perhaps don't warrant a three-member tribunal, don't warrant the full proceeding, you could have an expedited procedure instead. And the SCC was one of the leading institutions in introducing this system. Under the SCC rules, and I will talk about that later, it's an opt-in. So the parties must choose from the beginning an expedited procedure. However, we have made available to the parties also a number of model clauses where they can choose essentially the best of both worlds, where you start as a default with the expedited rules, but then if the case so warrants, it can be moved to the arbitration rules instead. We were also one of the first major institutions to introduce an emergency arbitrator mechanism. So essentially where the parties prior to the referral of the case to an arbitral tribunal could obtain interim relief from an emergency arbitrator. Our modernity also extends into the actual case management. So we have a number of digital solutions. In fact, since 2013, we have essentially been entirely paperless, apart from two things. And that is the notification of the case to the respondent to ensure that they have every opportunity to take part in the case, but also the final award. Very important that we have this in writing, a physical copy as well. But all of the case management is also conducted online on the platforms that we offer. And it is not just restricted to SCC cases. We also have an ad hoc platform available to parties, whether to an ad hoc arbitration or to an arbitration under other rules. They can use our ad hoc platform for the administration of their case. And then if we go to the next slide, please. So this is an overview of the different rules at the SCC and the different services. And as you can see, the majority of our cases, which probably will not be surprising, are arbitrations under the arbitration rules. But a very large number, over a third, are under the expedited rules. So we can see a range of different cases in terms of size, complexity, value being administered under the various different rules that we offer. Next slide, please. Last year, we administered cases with a total value of 13.5 billion euros. So to put this into context, I think the ICC, how much was that actually? Now that I've mentioned that one, I think SCIAC was about 14 billion USD.
And HKAC was right below.
Right. So this definitely puts us amongst the top arbitration institutions in the world. Next slide, please. And just to put this into the context of each of those cases, so that gives us an average amount in dispute of approximately 100 million euros for the arbitration rules, and then 672,000 for the expedited rules. So what we show with this is that the expedited rules are very much available to all parties, and the idea is to ensure the broadest access to justice possible for those perhaps smaller disputes that otherwise maybe would be priced out of going to arbitration. Next slide, please. Yes, for an overview of the actual cases and what kinds of disputes are coming to the SEC, as you can see, a lot of M&A disputes, over a quarter, and then we have delivery and transportation agreements, purchase agreements, and even employment agreements that are coming to the SEC. We would say that there is a trend of an increasing number of M&A disputes. I think last year was one of the highest number in recent years. But I think certainly since the pandemic, we've seen an increased amount of M&A activity, which does tend to result in a few additional disputes as well. Next slide, please. So one of our in Stockholm USPs, if you will, is our efficiency. So we are very proud of the fact that the majority of our cases are resolved within 12 months of the referral of the case to the arbitral tribunal. So over 60% of cases within 12 months under the arbitration rules. Next slide, please. And then almost 100% are resolved under the expedited rules within 6 months. Yes, thank you. Next slide. Why is Sweden preferred? Well, in addition to its neutrality, the Swedish courts are very pro-arbitration, very well respected. We have the Nordics have historically had one of the lowest levels of corruption in the world, which makes us, I suppose, an ideal neutral venue if you need to seek redress from the courts. They are, of course, well, maybe perhaps, of course, is no longer a given these days, but they remain an independent, it remains an independent judiciary. And of course, we dare to say that the fact that there is a renowned International Arbitration Institute in Stockholm gives a lot of parties comfort in coming to Stockholm as the seat of their arbitration, whether it's an SEC arbitration or an ad hoc. And as mentioned, we provide a very modern and digital service here, and Sweden is a very modern and digital economy. And this allows us to be quite quick and efficient. Also worth noting is when it comes to arbitration-related matters, the first instance in such cases is in general going to be the Court of Appeal. So you bypass what would ordinarily be the district court and can have a faster track to a final resolution if, for example, your award, there's an application to set aside. The statistics that we see is, of course, parties do try to set aside awards. And this is an important legal security, if you will. But in general, the success rate is incredibly low. I think, the cases challenged, approximately 6% are successful. And perhaps my colleague Sievers will be talking about one of the reasons why some of those cases were set aside shortly. This takes me to the SEC and our position. Even though we are independent of the state has recognized the importance in Sweden of arbitration and our profession. So the Ministry for Foreign Affairs specifically refers to the SEC and international arbitration in its strategy for Sweden's foreign trade, investment, and global competitiveness. And according to some figures, arbitration in Sweden accounts for approximately 0.25% of our annual GDP. So it's a very important profession and field in Sweden. And next slide, please. So I mentioned the ISDS, or the investment arbitrations, and the Stockholm position as one of the leading fora for the resolution of ISDS disputes. So the trust that many parties, and including states, have put in Stockholm and the SEC is something we do not take for granted, and are very much, the word escapes me at this point, but it is something that we really do value very much, this role that we have been given in this particular field. And historically, the SEC has been the second largest institute for investment disputes. And we are also often acting as the appointing authority under the UNCITRAL arbitration rules in ad hoc cases. So, for example, if there is an application coming to us for an appointment of an arbitrator, or perhaps even to challenge an arbitrator, we are one of the appointing authority is often selected by the parties for these matters. Now, last count that there are 96 international investment agreements that actually refer, currently in force, that actually refer to the SEC or Stockholm. And this is somewhat lower than it used to be, and we'll also mention why that is shortly. And to date, we have had 129 ISDS cases. I think in the interest of time, if we could move now to discussing some of the recent developments in Sweden, which is from slide 24, please, then I will hand over the word to my colleague.
Thank you so much. Also, good morning from me, or good afternoon or good evening, wherever you may be. Yes, very pleased to be speaking here today. I will briefly just cover two recent developments we've seen in Sweden and Europe lately. The first one is what we refer to as the seat policy. As Jake has mentioned, the SEC is quite involved in ISDS. And we're also one of two institutions mentioned in the Energy Charter Treaty next to ICSID. And this has, in Europe at least, given rise to what we now refer to as the seat policy. I am not sure how much European law and the European arbitration scene is part of everyone's professional life on a daily basis. So I'll just briefly recap what happened in Comstroy and the CJU's decision in Comstroy. So essentially, in Europe, what we have, the EU is founded on three fundamental treaties, and one of them is the Treaty on the Functioning of the European Union. And in this treaty, which is referred to as the TFEU, we have the so-called fundamental freedoms, which essentially protect exercises of commercial freedoms by individuals in certain cross-border EU commerce. So overly simplified, if I am a German distributor, I can sell a product with a certain packaging in Germany. These freedoms tell me I can, in principle, also sell the same product with the same packaging in France. And then if we go to the next slide, we have in Article 344 of the TFEU. Could we go to the next slide quickly? Thank you so much. We have a provision that essentially states that member states undertake not to submit a dispute concerning the interpretation or application of the treaties, so also of these fundamental freedoms, to any method of settlement other than those provided for therein. Now, there is a bit of dispute whether arbitration is provided for therein, but the majority opinion is that it's not. So essentially, the problem that we now have, if we have a relationship that concerns cross-border economic interests in the EU, this article tells us maybe these may not be submitted to arbitration. Now, if we look at the ECT, it will set out certain obligations and freedoms, such as fair and equitable treatment and so on. And these freedoms are quite close and quite similar, obviously, to what is protected by the TFEU. So if we go to the next slide, that was sort of the problem that the CJU then had, because there was a case that came from Paris to the CJU, where essentially the court asked, well, when you interpret provisions under the ECT, don't you really, in circumstances where you have two EU parties, don't you really interpret the TFEU as a tribunal, which would be in breach of Article 344? Now, I think the majority of the arbitration community said, no, actually, you're not interpreting the TFEU, but the ECT, because that's where the claim is brought. The CJU did not see it that way. They said you're interpreting the TFEU, and essentially in this decision in Comstroy thereby said this is in breach of Article 344, and so you cannot have ISDS essentially between in treaty-based arbitration between parties from the EU. Now, as mentioned, we are one of two institutions mentioned under the ECT, so we have a certain responsibility to ensure that the cases that come to us will be enforceable, or even before, will not be set aside at the seat. So what can we do? What we can do is we can say we see the issue, we see Comstroy, we see these decisions, and we will make sure that your award is enforceable. And we do that by setting the seat outside of the EU, so that the award will essentially not be set aside. And we've seen decisions from Switzerland, for example, which might be one of the seats where these cases will then be seated, that have rejected the decision in Comstroy and have said these awards are to be upheld. So this is something that works very well, and obviously this is something that we've done before. We released the seat policy in October last year. The seat policy was much more to clarify to the market that this is the practice of the SEC. That is the first current development, the seat policy. The second very current development is something that we just see unfolding now. We don't even have the decision of the CJEU yet. If we could go to the next, or maybe the slide even after that. And that is the case of Raoul v. Stanko Import. That is a case that was referred to the CJEU for preliminary ruling, and that comes from Sweden originally, from the Svea Court of Appeal that Jake has just mentioned. Now, if we go one slide further, the factual background is quite quickly explained. As you all are aware, recently there are obviously a lot of sanctions against Russian parties under multiple sanctions regimes. And these sanctions regimes often cover things like exports that should not be granted to Russia, or payments that should not be made to Russian parties. And one of the provisions is Article 11 of Regulation 833/2014. That's one of the big sanctions regulation. And it essentially says you shall not satisfy any claims to a Russian party. Now, in this case, what happened was Raoul was a Belgian party, Stanko Import is a Russian party. They concluded a supply contract, and Stanko Import, expecting delivery, made an advance payment of 2.6 million. Under the sanctions regime, the Belgian party was then not granted the export license, so could never export, could never perform. And Stanko Import then requested back their 2.6 million euros. This is obviously a bit on the edge, because you shall not satisfy any claims. On the other hand, it was only an advance payment for a performance that was ultimately not rendered. So Stanko Import went to a tribunal and actually got an award saying, yes, you will be getting these 2.6 million back. Raoul appealed, or moved to set aside the award here in Stockholm. And the court, the Svea Court of Appeal, before even going into the thing itself, then asked, are these claims even arbitrable? Because we've seen that the closer we get to EU primary law, the closer we get to the treaties, the more likely it is that the CJEU will say, no, it's actually not arbitrable. This is something that should not be discussed by a tribunal. The second question they asked was, if these claims are arbitrable, are they covered by public policies? So will we have a full review of sanctions-related issues in the court proceedings? And these questions obviously go to the very core of what is sanctions-related arbitration currently in Europe, because if the CJEU says these claims are not even arbitrable, we will see a lot of case law obviously erupt also in Europe on these claims. So this is maybe a brief summary of two very recent developments. First, the seat policy, where we set the seat in intra-EU disputes outside of the EU to ensure the enforceability of the award. And the second one is something where we expect the ruling in spring 26 from the CJEU on the arbitrability and public policy dimension of sanctions-related claims. That would be it for me for now. Thank you so much.
Yes, thank you. And do please feel free to keep in touch or ask us questions also offline if you have any.
Yes, thank you, Jake. I think there is one question put here. I'll just read it out. Yeah, my colleague is there. Yes.
Yes, sir. I think one of the question the participant has asked is, I'm to understand that verbal contracts are binding in Sweden. Have you come across any dispute arising out of such a contract in your experience there?
It's an excellent question, and it is true that oral agreements are binding, and this extends also to arbitration agreements in a domestic arbitration. Of course, it wouldn't probably be in conformity purely orally under the New York Convention, but what then becomes the question, of course, is one of evidence. How do we demonstrate that there was indeed a verbal contract if one of the parties is disputing that it ever did occur? I haven't personally seen any such agreement coming to the SCC, although it's not to say that there aren't questions that are perhaps orally understood or interpretations that we do see in our cases as well, where one party perhaps had one particular understanding that the other didn't, and maybe there were oral discussions behind that. But again, it comes to an evidentiary question. At the SEC, what we do is, with administering the case, we make sure that as soon as possible, the case goes to an arbitrator or an arbitral tribunal. We don't take any material decisions in the cases, apart from, well, and even these are more the procedure. So, for example, the selection, the decision on the seat in the absence of party agreement. So for us, the more important thing is to get the parties' matter as soon as possible to the decision maker, who can actually determine whether there was indeed a verbal contract.
Thank you, Jake, for the clarification about verbal contract. And takeaway, what I can see when the institutions were developing in the Global South, we were looking into SEC Institute has a Center for East-West. It's a combination, a bridge between East and West, particularly the former the Eastern blocs were doing the arbitration, considering Sweden to be a neutral venue. And now the shift to a new interesting thing, seat policy, very, very interesting. And it is a valuable point to be taken by the institutions and the sovereign states, in particularly from the Global South. It is excellent for sharing these, Jake and your colleague researcher. And it's a very interesting point, and this should be a good beginning for Global South to take this and move forward with your continuous support.
Thank you very much, sir.
Thank you so much.